my name is Amy and welcome to this Acas webinar, the Employment Rights Act 2025, April updates, required actions and implications. Now this webinar will focus on the main measures within the Act, what changes have already been implemented and when further changes are due, and what employers should consider in terms of preparation. Before we get started, just a little about who Acas are and what we do. So Acas has been around for 50 years now. We're a non-departmental public body. So that means we receive funding from the government through the Department for Business and Trade, but we act independently. We provide employees and employers with free, impartial advice on workplace rights, rules, and good practice. This includes guidance on our website, our telephone helpline, and importantly for us today, through our codes of practice. We also offer training. We help resolve disputes through a number of services, including conciliation, mediation, and arbitration. And our website has a number of free template letters, forms, and policies for employers, HR managers, and employees, which are free to download and use. In this section, we will look at the finalised content of the Employment Rights Act 2025 after finishing its journey through Parliament. Before we get into the changes, let's look at an overview of what the Employment Rights Act does. Since the Employment Rights Bill received royal assent, it's now referred to as the Employment Rights Act 2025 and has become law. Now, this doesn't, however, mean all changes will take effect immediately. Some changes are already in force. However, most changes are still to happen and will come into force in phases throughout 2026 and 2027. The Act introduces a wide range of reforms across areas such as sick pay, dismissal, trade union rights, and family rights. The Act will change some already existing rights, for example, removing or reducing qualifying periods. It will also introduce some new rights, for example, the right to guaranteed hours. As mentioned, many of the changes are being brought in gradually. However, it is important to note that some changes relating to trade union activity, changes to paternity and ordinary parental leave, and sick pay changes have already taken effect. We will cover these in more detail later in the presentation. Most of the changes are due to be phased in across the next 2 years. The final details for some changes are yet to come following consultations and secondary legislation. Here at Acas, we will play a crucial role in supporting the Act's implementation, helping employers and employees prepare for the changes through developing detailed advice on all aspects of the new legislation as they take effect, by updating our statutory codes of practice to ensure employers and workers understand their legal obligations and good working practices, providing a range of training and support, including webinars, workshops, and resources. We will continue to provide expert, impartial conflict resolution through our conciliation and mediation services, and you can sign up to our newsletter on our training website for regular updates to law and information about the training we offer. You can also keep track of what's happening and when through our dedicated Employment Rights Act website page, which is linked on the screen. Or it can also be found in the news and updates section of our website homepage. It's a really useful resource. Now, to help deliver of the Employment Rights Act, the government is publicly consulting to gather the views of employers, workers, and representative bodies on additional detail for specific rights. Some consultations, such as one on tipping law, have recently closed, but consultations which are currently open are protection from detriments for taking industrial action, which has a closing date of the 23rd of April 2026. There's also a consultation on improving access to flexible working, which closes on the 30th of April 2026. 2 consultations close in May, Firstly, modernising the agency work regulatory framework, which closes on the 1st of May 2026. And finally, the consultation on the threshold for triggering collective redundancy obligations, and that closes on the 21st of May 2026. You can find out more and get involved at gov.uk, and the full link is available on the screen. We will now take a look at some of the new measures the Employment Rights Act intends to deliver. We'll start by looking at unfair dismissal. Now, the reform on unfair dismissal has changed significantly while going through Parliament. Now, the initial proposal was to introduce unfair dismissal protection from day one, alongside an initial period of employment where a new set of rules would apply when dismissing someone. Now, the government changed this before the bill became law to reduce the qualifying period for protection from unfair dismissal from 2 years to 6 months, with a planned start date of 1st of January 2027. This is aimed to strengthen employment rights, reduce one-sided flexibility in the workplace, and increase job security for employees, whilst ensuring employers have flexibility to hire and make HR decisions. Additionally, from the 1st of January 2027, the current compensation cap for a successful unfair dismissal award will be removed. Currently, pregnant women and new mothers are protected from discrimination and dismissal linked to pregnancy or maternity leave and have enhanced rights in redundancy situations. The Employment Rights Act provides powers to introduce regulations to extend protection to cover other types of dismissal, which are not redundancies, taking place during pregnancy and other types of family leave or following a return to work from family leave. A consultation took place on this provision. This closed on January 15th, and the results are currently being analysed. The consultation explored options on how to define specific circumstances in which it would or wouldn't be lawful to dismiss any pregnant employee, and when protection should start and how long that protection might last. So, for example, 6 months after return from maternity or 18 months after birth. Additionally, dismissal and re-engagement, also commonly referred to as fire and rehire, is an area where protections are being strengthened. The planned date for changes to come into force is the 1st of January 2027. It will become an automatically unfair dismissal where an employee is dismissed and rehired, or dismissed and replaced with someone else in order to change specific terms and conditions in their contract. These terms are called restricted variations. However, in this situation, there will not be an automatic unfair dismissal where the employer can show they are in severe financial difficulty, that the changes to restricted variations significantly reduce those financial difficulties, and there is no reasonable alternative to making those changes. A consultation has taken place and closed on the 1st of April. This explored what types of terms and conditions will be treated as a restricted variations. The government is looking at 2 types of terms and conditions, which are employment expenses and benefits and shift patterns, and sought views on which types of expenses, benefits, and shift changes shouldn't be considered as a restricted variation. The aim is to protect employees from negative changes to their employment contracts while still letting businesses adapt when needed. Secondary legislation will be introduced to set out the detail needed based on the consultation outcome. We will update our guidance once we have the details of the finalised regulations, and the government will also be looking to provide an updated code of practice on dismissal and re-engagement in 2027, and will consult on that publicly. The Acas website page for the Employment Rights Act is updated with the latest information on details and dates for reforms. Let's look now at changes to statutory sick pay under the Employment Rights Act. Now, these changes, which took place on the 6th of April 2026, represent a significant shift in how sickness absence is supported for all employees that get statutory sick pay, often referred to as SSP. So under the previous system, employees had to wait until day 4 of a sickness absence to be eligible for statutory sick pay. The new law provides that sick pay will be paid from the first day they are unwell. Employees also previously had to earn above a minimum weekly threshold, known as the lower earnings limit, to qualify for statutory sick pay. This requirement has been removed. These changes bring many more people into scope to receive sick pay and means that those who already qualified for sick pay will receive payment earlier, helping support people who are on low incomes. The intention is to reduce situations where employees feel forced to work while unwell due to lack of income, which has broader health and productivity implications. Now, of course, an employer can still choose to top up statutory sick pay to full or half pay for their employees, should they choose to do so. But it's important to note that statutory sick pay remains a statutory amount rather than full pay and is subject to an employee meeting the qualifying criteria. Employers should ensure they have reviewed sickness absence policies, updated payroll and HR systems, and trained managers to understand statutory sick pay eligibility. Clear communications with employees will be essential, so expectations are properly set and working relationships are maintained. We're also going to just go look at a short case study to see how the changes to sick pay work in action. So meet Sophie. Sophie works part-time in a cafe and previously did not qualify for sick pay as she earns £100 per week, which is below the lower earnings limit. In May 2026, she breaks her wrist and needs to take sickness absence. Now, she is worried about how she will cope financially and is unsure whether she qualifies for statutory sick pay. Sophie contacts her manager to let them know what has happened and to ask what she might be entitled to. So what advice should her manager give? So now let's meet her manager, Carl, to see what advice he does give. So Carl receives a phone call from Sophie, who explains she's broken her wrist and that she won't be able to come to work. Sophie explains that she isn't sure about whether she can get sick pay, as in the past she has been told she earns too little. Now, Carl knows there has been a change to sick pay entitlements recently and contacts payroll to check his understanding. Payroll explained that because the lower earnings limit has been removed, Sophie is now eligible despite her lower earnings. The rule is that sick pay received is the lower of either £118.75 or 80% of someone's normal earnings. Carl explains to Sophie that as she earns £100 per week, 80% of her pay is £80. Because that is lower than £118.75, Sophie is entitled to £80 per week sick pay. As good practice, Carl also confirms this in writing. Carl reminds Sophie that she will need a footnote if her absence is to last more than 7 days, and arranges to call her in a couple of days to check in to see how she's doing. Now, this slide brings together several important family-related leave rights and enhanced protections introduced under the Employment Rights Act. The focus is on supporting parents while reducing the risk of disadvantages linked to pregnancy, loss, or parenting responsibilities. Now, significant changes to paternity leave and parental leave took effect on the 6th of April 2026. The previous qualifying periods for these rights, which is 26 weeks for paternity leave and 1 year for parental leave, have been removed, with the Employment Rights Act making them a day one right. This means paternity and parental leave will be more accessible and support early bonding and shared caring responsibilities. Employers need to ensure that managers understand eligibility from day one, that payroll systems can apply statutory paternity pay correctly, and employees are not discouraged from taking paternity leave even if they have just started their employment. Newly eligible parents will be able to give notice that they are eligible to take paternity leave or unpaid parental leave once it becomes a day one right on the 6th of April. From the 18th of February 2026, new eligible employees have been able to give notice of their eligibility to take leave, with the notice period being temporarily reduced from 15 weeks to 28 days. You can find out more about this temporary provision on the Acas website. Another important change is the removal of the restriction on taking paternity leave after taking shared parental leave. Now, this allows partners greater flexibility in how they can take the leave, and as a result might encourage more families to share leave. Historically, shared parental leave has been underused. The Act improves clarity. Employers should prepare for greater awareness and uptake going forward. Bereavement leave will also be expanded with the right to unpaid bereavement leave, including following pregnancy loss before 24 weeks, with changes planned to take effect in 2027. The consultation on this closed in January, and the government is now analysing the feedback to shape the final details of this new right. It sought views on who should be eligible for this leave, potentially including non-traditional family members and various forms of pregnancy loss, as well as the timing, duration, flexibility, notice, and evidence requirements for taking this leave. The focus here is on providing space to grieve, reducing pressure to return to work too quickly, and protecting employees from unfavourable treatment due to bereavement. Clear policies and compassionate management will be essential. Linked to these rights, a separate piece of legislation that is not part of the Employment Rights Act came into force on 6th of April. Now, this new law provides eligible fathers and partners to be able to take up to 52 weeks of unpaid bereaved partners' paternity leave if the primary carer or primary adopter dies. Now, bereaved partners' paternity leave can only be taken after the bereavement date and during the paternity leave eligibility period. The paternity leave eligibility period is 52 weeks, beginning on one of three events. So that is the day after the birth or parental order, the day after the child is placed for adoption, or in the case of overseas adoption, the day after the child enters Great Britain. For example, if the bereavement happened 20 weeks into the eligibility period, the employee would be entitled to take up to 32 weeks of leave. There is a limited exception to this, where the bereavement occurs less than 14 days before the end of the 52 weeks. In this situation, the employee would have the right to take up to 14 days leave. Now, there are specific notice rules associated with bereaved partners' paternity leave. Keep an eye on the Acas website for further information. It is also important to remember that an employee may not wish to take all the leave that they are entitled to, and the situation should be approached with sensitivity. Employees should review and update current family and compassionate leave policies, and also ensure managers are equipped to handle these requests consistently. And as we previously mentioned, safeguards against detriment, redundancy and dismissal will apply to these rights. This slide looks at new rights for people working irregular hours, including those who work through an agency. These reforms aim to balance flexibility with greater security for workers who currently face unpredictable income insecurity. One of the core proposals is that a worker who has been working regular hours over a set reference period, likely to be around 12 weeks, will have the right to be offered a contract with guaranteed hours reflecting the typical pattern of work, with an exception for seasonal or temporary work. For employers, this means reviewing how 0-hour and low-hour contracts are used and being prepared to offer contracts that reflect actual work patterns once the worker qualifies under the reference period. There will be a consultation to determine how this will work, including the detail of any exceptions. Secondary legislation is expected to bring into force the right in 2027. The right to reasonable notice of scheduled shifts, notification of changes to shifts, and cancellation of shifts is also set out in the Act. Employers will need to put systems in place to notify workers of their shifts with sufficient lead time. They should also document communications to demonstrate compliance and to mitigate the level of risks of disputes over cancellation or changes to shifts. If a shift is cancelled or moved at short notice, workers will have a right to compensation. The details will be set out in secondary regulations after a future consultation. Agency workers will receive the same protections as directly engaged 0-hour or low hours workers, including rights to guaranteed hours, reasonable notice, and shift cancellation pay. The agency and hire will be jointly responsible for giving reasonable notice of changes to shifts to workers. However, the agency will be responsible for any short notice shift cancellation or curtailing payments, although parties can come to an agreement on compensation. So what can employers do to prepare? They should audit how 0 hours, low hours, and agency arrangements are currently used. They should also review shift scheduling and notice protocols and update contracts. Employers should think about how they will communicate with workers and engage with agencies to clarify responsibilities and monitor regulations that will specify reference periods, notice thresholds, and compensation formulas. Now, this slide explains the changes to collective redundancy rules being introduced under the Employment Rights Act. These reforms broaden when consultation obligations arise. Currently, collective redundancy consultation is triggered where an employer is proposing to dismiss 20 or more employees at one establishment within a rolling 90-day period. Under the new Act, the site-specific test remains, but a second trigger will be introduced based on redundancies across the employer's entire business, regardless of location. The circumstance in which this will be required is still to be determined through a consultation. This change is planned to take effect in 2027. Previously, failing to collectively consult properly can result in protective awards of up to 90 days pay per employee. From 6th of April 2026, this increased to 180 days pay per affected employee. We will look at when other changes come into effect later in the presentation. For organisations operating in multiple locations, the introduction of a business-wide collective redundancy trigger means central HR tracking systems are essential. Local site counts will no longer be sufficient. Planning and coordination across the organisation are critical to ensure consultation triggers are identified early. To prepare, review redundancy and consultation policies, implement central reporting of redundancy plans across all locations, and engage early and genuinely with employee representatives. Early and thorough consultation not only complies with the law, but often leads to better outcomes for both business and affected employees. Under the Employment Rights Act, a significant structural change has been proposed: the creation of a single enforcement body to cover enforcement of specified rights, known as the Fair Work Agency. The Fair Work Agency, or FWA, was established on the 7th of April 2026 and brings together functions previously exercised by various government enforcement teams. This includes the Employment Agency Standards Inspectorate, HMRC's National Minimum Wage Enforcement Team, and Gangs Master Labour Abuse Authority, which covers modern slavery. Now, the Fair Work Agency will also add new areas for enforcement, such as for holiday pay. This unified approach means workers will have a clear single point of contact for enforcement of specified rights. The FWA will be able to inspect workplaces for compliance, issue notices requiring payment of underpaid statutory entitlements, for example, statutory sick pay, impose penalties, and bring civil proceedings and pursue enforcement through tribunals or courts. It can also provide legal assistance to workers when appropriate. Whilst the Fair Work Agency has now been established, it won't assume responsibility for the previously mentioned functions and enforcements. There will be a period of development to establish how it will cover its intended purposes. With the creation of the Fair Work Agency comes an expectation that employers will maintain detailed records. Employers should review record keeping and payroll systems and ensure pay and leave entitlements are clearly documented. Notably, from the 6th of April, there will be an obligation for employers to keep records for 6 years regarding holiday pay, payment in lieu of holiday, and holiday taken. If an employer fails to comply, it will be punishable by a fine. The Employment Right Act will be implemented in phases. So this started in December 2025 and is currently planned to continue through to 2027. This section of the webinar will discuss when the multiple reforms are proposed to take effect. Royal assent for the legislation was given on the 18th of December 2025. This is the point the bill formally became law. As previously mentioned, this does not mean all new rights immediately came into force. It will be rolled out in stages over several years. Changes that took effect in February 2026 repealed some parts of the Trade Union Act 2016 and simplified industrial action and ballot notices. Following this, with the start of the new tax year, we have just seen the next major rollout phase. So for many organisations, this will be the point where policy updates, system changes, and manager training become essential. Beyond April 2026, additional reforms are expected to come into force later, particularly where the changes are more complex and require consultation and secondary legislation. There are changes planned for August, October and December in 2026, and the extended timeframe reflects the scale of change and the need for detailed regulations before the full rollout, leaving some changes falling into 2027. Now, this phased approach gives employers time to prepare, but it also means compliance planning needs to be ongoing, not a one-off exercise. It's important to track which rights apply at which stage, which we will look at next. So, royal assent or soon after. So on the 18th of December 2025, we saw royal assent. On royal assent, the Strikes Minimum Service Levels Act was repealed and is no longer in force. From 18th February 2026, dismissal for taking part in industrial action become automatically unfair. This removed the 12-week limit for claiming unfair dismissal. The time needed to give notice of industrial action was reduced to 10 days instead of 14 days, and picket supervisors are no longer required. Also in February 2026, changes mean that industrial action mandates now last for 12 months instead of 6 months. Industrial action and ballot notices are simplified, and political fund rules were changed. The support threshold rule has also been removed. Now, this rule required at least 40% of the total eligible votes to support action for the ballot to be valid. It applied to important public services. Public and private sector ballots now follow the same requirement. They only need more votes in favour of industrial action than against. The turnout threshold rules for industrial action ballots will remain until August 2026. This rule requires at least a 50% turnout for industrial action ballots for the ballot to be valid. The following changes came into force on the 6th of April 2026. The maximum amount of a collective redundancy protective award for failing to consult properly was doubled from 90 days to 180 days pay. Paternity leave and unpaid parental leave are now available as a day one right. Sexual harassment has been added as one of the protected disclosures under whistleblowing protections. This means that someone who has made a qualifying disclosure about sexual harassment will be protected from detriment and dismissal under whistleblowing law. As previously mentioned, the removal of the lower earnings limit for statutory sick pay has been removed, and statutory sick pay will also be payable from day one of absence rather than from the 4th day as under previous rules. Whilst there has been some concern about this leading to an increase in people taking sick days, it does not impact an employer's ability to effectively manage absence, and employers and employees should still work together to deal with root causes of work-related absence and focus on reducing absence by promoting a healthy working environment. Also taking effect in April, how a trade union can be recognised in a workplace is simplified, and employers will also have a duty to keep records of annual leave and holiday pay from 6th of April, and they must keep these records for 6 years. Employers will be able to and should consider creating and publishing action plans around menopause and gender pay gaps. Doing this on a voluntary basis gives employers the opportunity to learn how to do it before it becomes mandatory. The new requirement that will come into force in 2027 will apply to large employers with 250 or more employees. This mirrors the existing gender pay gap reporting obligations. Now, the Office of Equality and Opportunity have published guidance outlining a new framework for employers to publish equality action plans, and you can find this on the gov.uk website. And finally, for the April changes, on April the 7th, the Fair Work Agency body was established. The changes planned for August 2026 are that trade union members will be able to vote electronically or in person in ballots for industrial action, union elections and other statutory ballots if the employer and trade union agree. After that, the removal of the requirement for a 50% turnout for industrial action ballots can begin, and this had originally been expected in April 2026. The laws we will see in October 2026 are the establishment of the Adult Social Care Negotiating Body, which will negotiate fair pay agreements for the sector. The regulations will include what it will do and how it will work in practice. The intention is for the first negotiation to take place in 2027 and the first finalised agreement to be implemented for the adult social care sector in England is intended to be April 2028. This is a devolved matter, and so the Scottish and Welsh governments will implement this themselves. There will also be an introduction of a procurement two-tier code. This will set out measures to avoid the creation of a workforce consisting of ex-public sector employees and private sector employees, with each group on different terms and conditions. This will be governed by both regulations and statutory code of practice. Tipping law will be updated, so employers, as recommended in the Code of Practice published in 2024, should consult with workers on or their representatives before creating a tipping policy for the workplace. The Act also requires that these policies are reviewed at least every 3 years. There is a public consultation on this that is open until April 1st, 2026. So that will be closed now. The consultation will review how the existing legislation operates in practice, identify where improvements could be made, and consider how we can most effectively implement the new requirements. So another thing to look out for in October 2026, we'll see more changes to trade union rules. Employers will have a duty to inform workers of their right to join a trade union. which should be issued alongside their written statement of employment particulars on or before someone's first day of employment. There will be updated laws on a trades union's right of access to the workplace, with the introduction of a framework for access agreements between an employer and trade union. This would permit a union to request access rights from the employer for specific purposes, such as to meet, support, represent, recruit, or organise workers or facilitate collective bargaining. Further changes in October are the introduction of new rights and protections for trade union representatives, which include a right to reasonable accommodation and facilities for trade union representatives when carrying out their duties, and a right to time off for union equality representatives to carry out relevant duties. There will also be extended protections against detriment for taking part in industrial action. So workers taking industrial action will be protected, not just from dismissal, but poor treatment short of dismissal. New protections relating to sexual harassment are planned. Employers will become liable for harassment from third parties and will need to take all reasonable steps to prevent sexual harassment. The law is expected to specify what all reasonable steps means in 2027. A change to law around non-disclosure agreements or NDAs is also expected. It will avoid clauses that would prevent workers from alleging or disclosing relevant work-related harassment or discrimination. However, a date for this change has not yet been confirmed. And finally, in October 2026 is when the planned extension of employment tribunal time limits will take effect. This increases the time limit to make a claim to 6 months from the current 3-month time frame that applies to most claims currently. So for employers, this will mean that retention policies under GDPR may need to be amended, or records may need to be kept for longer under the new rules. In December 2026, the Mandatory Seafarers Charter is expected to take effect. This is sector-specific legislation, but it will set higher standards for seafarers on services regularly calling at UK ports. The protections for seafarers include ensuring fair pay, job security, adequate rest breaks, and health and safety. And then we have 2 changes planned for the 1st of January 2027. The first of these is limiting the use of fire and rehire practices. There is an existing statutory code of practice introduced in April 2024. Now, the code states its purpose ensures an employer takes all reasonable steps to explore alternatives to dismissal and engages in meaningful consultation with a view to reach an agreed outcome with employees or their representatives. It seeks to make sure employers do not raise prospect of a dismissal unreasonably early or put undue pressure on employees by threatening dismissal where it's not envisioned. Alongside the updated law on dismissal and re-engagement, the government intends to issue a revised code of practice to support these changes in 2027. Now, the second change planned is that protection from unfair dismissal will become a right after 6 months of being in a job, replacing the current requirement of 2 years continuous service. Additionally, the limit on the compensatory award for unfair dismissal will be removed. So consider training managers on effective performance management and how to effectively use probation periods. If you don't already have policies in place, you can check out Acas training, webinars and e-learning by using the training tab on our website. Further changes planned for 2027 do not yet have dates for coming into force, but those changes are 0-hour and agency workers amendments, a right to payment where a shift is cancelled, moved to another date or cut short by the employer, and that employers must provide reasonable notice of shift changes and cancellation of shifts. Flexible working law will also be amended. Currently, an employee can request flexible working from their first day of employment. An employer can only refuse based on one of 8 statutory grounds. For example, it would have a detrimental impact on performance. Under the new changes, an employer still needs one of the 8 reasons to turn out a request, but additionally, the employer must state the grounds for refusing it and must also explain why they believe the refusal is reasonable. A consultation for this change closed on the 30th of April. Acas will also need to update our code of practice on flexible working to bring it in line with this reform and provide guidance. Acas will be publicly consulting on an updated version of our flexible working code ahead of this change coming into force. From 2027, large employers of 250 people or more must produce and publish the action plans to address their gender pay gap and to support employees going through the menopause, as mentioned in the April 2026 section. They will have to do this on the gov.uk site alongside their gender pay gap reporting. Now, smaller employers should still consider doing this as good practice and will also be able to publish in the same way. There will also be regulations to give more protection from dismissal for pregnant workers, and following the changes to legislation regarding the prevention of sexual harassment in October 2026 and 2027, a power in the Act will come into effect. This will enable the government to introduce regulations that will specify what steps are to be regarded as reasonable steps to determine if an employer has taken all of those reasonable steps to prevent sexual harassment. In 2027, there will be an extension of the probation on blacklisting based on trade union membership or activity. This is intended to cover lists created by artificial intelligence or predictive technology. There will be a new industrial relations framework introduced to foster productive and constructive engagement where disputes arise. And regulation of umbrella companies will take effect in 2027. The Act expands the definition of an agency to include umbrella companies. This will enable enforcement by the Employment Agency Standards and the Fair Work Agency. After consultation, the government will amend the law to set out the framework. The consultation is live until the 1st of May and is wider than originally intended. The government is seeking views on reforming the whole range of agency worker laws and regulations, as well as how to incorporate umbrella and companies. Remember, you can have your say by taking part in that consultation through gov.uk. 2027 will also see changes to the collective redundancy, collective consultation threshold. And finally, to be introduced in 2027 is the right for all employees to bereavement leave. This is in addition to the already existing right to parental bereavement leave. This includes for parents who experience pregnancy loss, sometimes called a miscarriage, before 24 weeks of pregnancy. So in this last section in the webinar, we have covered what is in the Employment Rights Act and phase changes and timelines, and we've already mentioned a few things that employers should be considering. But in this final section, we're going to now focus on practical steps employers can take. On this slide, we're looking specifically at HR and policy updates. So with the introduction of more day one rights, employers should review family leave policies to make sure eligibility processes and guidance for managers are clear and that everyone is up to date with these changes. Absent policies should clearly explain reporting procedures, evidence requirements, and how absence is managed in a fair and supportive way. When unfair dismissal protection is applied from 6 months, probation processes may become even more important. So employers should ensure expectations are clear, feedback is documented, and that decisions are fair. The new duty to prevent harassment places greater emphasis on preventative measures. Policies should be clear on standards of behaviour, reporting routes, and how concerns, including third-party behaviour, are handled. Flexible working policies should clearly explain how requests are handled and how decisions are explained if they aren't already. And with higher protective awards, effective consultation becomes even more important. Policies should reflect meaningful engagement and clear communication. The key part here is that this is not about rewriting every policy at once, but checking that existing policies are fit for purpose, consistently applied, and aligned with the changes to the law. Communication plays a key role in how these changes are understood and experienced in the workforce. Employers should be clear about what changes will affect their workplace, when those changes are expected to happen, be open about the phased nature of the changes and what isn't yet confirmed. This can help build credibility and set expectations. Inconsistent messaging can undermine trust, so ensure that HR, managers, and senior leaders are aligned in what they are communicating about the changes. Engaging early with employee representatives and trade unions can help ensure employees and workers are kept informed and consulted. And now, final takeaways. So to close this presentation, we want to highlight a few final takeaways. The Employment Rights Act brings a significant reform, but as we have outlined, it is being introduced in phases. Many of these changes rely on consultation and secondary legislation. Employers, workers, and representatives can take part in consultations published on gov.uk. This is an opportunity for you to share practical insights on how these changes may work in real workplaces. Acas will continue to provide impartial guidance as further details emerge. And for further support, Acas provide a number of free resources that you may find useful. For example, we have templates that you can download free on our website, and these are for employers but also for employees. Acas free webinars run regularly, and we also make past webinar recordings available, so you can watch them at a convenient time. The link is detailed on the slide. You can keep up to date with Employment Rights Act changes on our dedicated website page. Our free online advice and guidance is updated regularly. Acas also offers a variety of support and training options to suit your business needs and equip you with more in-depth knowledge. We have a wide range of training products available on topics discussed in today's event. That's including absence management, working effectively with trade unions, and that is in collaboration with the CIPD, managing discipline and grievance. Our digital courses are delivered to you via Zoom and will give you the opportunity to interact with our knowledgeable trainers and explore some of the challenges you may be facing. We do also offer face-to-face training at various locations around the country, and we can also deliver training in-house for you. And again, that's either in person or via digital platforms. We also have a regular free newsletter to help keep you up to date with new guidance, employment-related news, and scheduled training events. So you can sign up to that on our website. Thank you for watching, and goodbye for now.